30th July 2024, Malaysia Court of Appeal had sentenced 6 former students of UPNM to death penalty for the murder case of Zulfarhan Osman bin Zulkarnain. 2017, Malaysia was shocked by the tragic death of a 21-year-old UPNM student named Zulfarhan. The situation started when Zulfarhan was accused of taking a laptop that belonged to the first accused, Akmal Zuhairi bin Azman. A group of students attacked him to extract a confession, administering multiple punches, kicks, and hits. After Zulfarhan passing, 32 students from UPNM were detained. Among the 32 students, 19 faced charges under Section 330 of the Penal Code for intentionally inflicting harm to obtain a confession. 5 students faced murder charges under Section 302 of the Penal Code, while 1 was charged with abetment under Section 302 and 109. To establish a prima facie case, the prosecution need to prove beyond a reasonable doubt that all of the accused had fulfilled the elements of crime, which are the actus reus and mens rea. We had analysed on how does the prosecution in Zulfarhan case prove this element in the court. In proving actus reus, it was proved by the statement of the prosecution witness and also the burns on Zulfarhan's body. Based on the prosecution witness, all of the accused except the 78 were involved in 1 out of 3 events of Zulfarhan torment. It was described detailedly by the prosecution witness that all of the accused who involved had beaten Zulfarhan to extort the confession, and also including the most vicious event which involved a steam iron. For mens rea, based on SP 25, Tuturut 1 Akmal Zuhairi bin Azman specifically mentioned his intention to beat Zulfarhan in order to extort a confession out of him. For other accused, this is where the common intention principle applied.
In criminal law, common intention, as defined under Section 34 of the Penal Code, ensures that all individuals involved in a criminal act with a shared purpose are equally liable. So this principle is critical in holding all participants accountable regardless of their specific roles in the crime. So the tragic case of Zulfarhan Zulkarnain highlights that the power of common intention. 6 individuals, T1 until T6, acted with a shared plan to inflict harm towards Zulfarhan. T1 to T5 physically inflicted severe burns using a steam iron, while T6 orchestrated the act as the instigator. So despite not directly harming Zulfarhan, T6 leadership and encouragement were integral to the crime. So the High Court found that their coordinated actions driven by a unified intent demonstrated a clear common intention. So this shared purpose made each participant equally responsible for the horrific outcome.
Moving on to defences. In this case, the accused raised several defences to lessen their culpability. They argue lack of intent with OKT1 and OKT2, claiming the use of a hot iron was to extract information and not to cause harm. OKT5 cited cultural norms at UPNM, portraying the interrogation as a routine practice among cadets. OKT4 and OKT3 pointed to group involvement, asserting shared responsibility instead of individual blame. Despite these defences, the court found overwhelming evidence of intent to harm, including severe torture and disregard for human dignity. Initially, the charge was reduced to culpable homicide under Section 304, subsection A, but the prosecution appealed, citing legal precedents. The appellate court determined the trial judge erred in downgrading the charge. It reinstated the murder conviction under Section 302, emphasizing the severity of the defendant section and upholding justice for Zulfarhan.
The tragic death of Zulfarhan Zulkarnain raises profound questions about justice and also punishment. Personally, we support the Court of Appeal's decision to impose the death penalty on the 6 primary offenders. We believe it serves as both retributive justice for Zulfarhan and a deterrent against future acts of such brutality. However, SUHAKAM, which is the Malaysia's Human Rights Commission, holds a different view. They strongly oppose the death penalty because they emphasize its irreversible nature and advocating for rehabilitation as a more humane and just alternative. SUHAKAM's stance aligns with global trends towards the abolition of capital punishment, which they emphasize that the potential for redemption even for those who commit severe crimes. While we share SUHAKAM's commitment to justice, we differ on the approach. In cases like Zulfarhan's, we believe that where the crime reflects the extreme cruelty, we believe that the harsher penalties are necessary to uphold the accountability and also to societal order.